5, 4, 3, 2, 1. The judgment of the court was delivered by SAWANT J Leave granted in SLP numbers 14525 and 4912 of 1991. This group of appeals raises an important question with regard to the status of the law officers engaged by the state government to conduct the cases on its behalf in the High Court. Incidentally, questions bearing on the profession of the lawyer, his relationship with his client, and the relationship of the government, and for that matter of all the public bodies with the lawyers they engage for conducting their matters also fall for consideration. At the relevant time, there were 64 law officers working for the UP state government in the High Court of Allahabad, including its Lucknow Bench. By an order dated July 23, 1990, the state government removed 26 of the said law officers. Out of these, 9 law officers had been working for a long time, some of them for more than 15 years. Their continuation as law officers was till further orders. Another 11 officers out of the removed officers had been appointed in 1982-83 and they continued to work till the date of their removal without renewal of their term. The remaining 6 law officers were appointed variously in March and May 1989 for a period of 1 year only, with a stipulation that they could be removed any time without giving any reason whatsoever. Their term had also not been renewed after the expiry of the initial period of their appointment. There is no dispute that in cases of all these 26 officers, and indeed in cases for all the law officers appointed in the High Court, the terms of appointment contained a condition that, notwithstanding the period for which they were appointed, they could be removed at any time without giving any reason whatsoever. It appears that before issuance of the aforesaid order of removal dated July 23, 1990, the state government had issued another order on May 26, 1990, by which the system of engaging brief holders in the High Court was abolished with immediate effect. By yet another order of June 28, 1990, the government had authorized the legal remembrancer to appoint special counsel for any special matter before the High Court. The order also gave him financial and administrative powers which were earlier exercised by the Chief Standing Counsel and the Public Prosecutor. He was further given power to distribute the work to the various Standing Counsel and the additional Public Prosecutors. Aggrieved by the order dated July 23, 1990, the law officers who were removed from their posts, and aggrieved by the order of May 26, 1990, the then brief holders approached the High Court by a writ petition contending, among other things, that their removal was against the principles of natural justice and that they could be removed from their offices only for valid reasons. The High Court accepted the contention of the law officers and by its impugned judgment quashed the orders removing them from their offices. PDF लिंक डिस्क्रिप्शन बॉक्स में है.